in our next topic, we will hear more about the environmental component of ESG. And also we're going to hear about the Shell case. I briefly mentioned the Shell case already. It is my great honor to introduce to you Mr. Leonardo Sempertegui. Since 2018, Leonardo has been general legal counsel in the OPEC. I think OPEC needs no further introduction. Leonardo leads OPEC's efforts to support OPEC's member countries in energy-related policy and legal areas. So please, Leonardo, please take it away. We're looking very much forward to your presentation.
Thank you very much and good afternoon. I hope you can hear me. Wonderful. It's a great pleasure to be here. The topic of my presentation is a bit, I don't want to say all over the place, but it allows me to be touching several aspects within the framework of this great webinar that's gonna span today and next Friday. So I would like to share my presentation in order to make this efficient in terms of time. You kindly invited me to speak about emissions reductions, the Royal Dutch Shell, the Shell case, the environmental component of ESG. This allows for a wider conversation because, as you can imagine, we're trying to bring a different perspective in the conversations where we participate. Because let's be honest, many of the conversations that we have around the topic tend to be centered in the developed countries' needs and situation, and the world is wide and vast, and the situation of multiple countries, of most countries around the world, sharply differ from what's happening in Europe, which I'm happy and glad to see that it's going through an electrification process as much as it's possible, even though that model has been proven limited following the last geopolitical development. So I think that ESG is an important matter to be discussed, but as we will see during this presentation, the principles that the E component of the ESG is bringing is nothing new. They have been in legislation and they have been in the international law context for quite some time, and I want to say decades at least in most of the cases. Therefore, it's good to take the right of the ESG as a label to get things done. But let's not get confused in the fact that we're bringing something extremely new to the table. Corporations have had the obligation to observe law and conventions for decades. And yeah, I mean, if the ESG as a phenomenon helps for that, wonderful. That would be my approach in general terms. But let's go from the beginning, if you allow me. I just want to say a few words regarding the Shell case because it was already mentioned, but it's a good way to start discussing the problem. The court in The Hague spoke about a violation of an unwritten standard of care. This is a standard of care that is not in the text of any law, but it is drawn from a combination of sources. And that's what the court brought to the table as a new element in the climate litigation process. So they said, okay, we have some obligation in the civil code, in the Dutch civil code, but also we have other instruments that somehow create an ecosystem where an obligation stems for the company. Political and policy commitments and statements included in different kind of instruments that were not necessarily binding, political declarations, manuals, corporate plans, etc., that normally are used as guides of corporate responsibility or best practices for corporate responsibility. But also obligations included in international treaties like the UNFCCC system, human rights regional conventions, in which corporations are not parties, but states are parties, were also used for this contextual obligation. And of course, the court drawn into the scientific reports that have wide global acceptance, for example, the IPCC report. So the extension of the duty of care, of the standard of care, was quite wide. And I guess that many lawyers in the sector agree that it was relatively surprising because this extension is of legal theory this is an extension of legal theory to private entities, which is based on things, on legal instruments, or in instruments, not even legal, but scientific instruments or other kinds of instruments where the corporation was not even a party. But anyway, the litigation I mean, the litigation is still ongoing itself as a case, as we all know. There is an appeal that was presented by Shell, and certainly this case is going to run its course completely, even if Shell prevails on the appeal or not. We know that what happened in Uganda, it went into the Supreme Court even, or, you know, I'm not familiar with the Dutch system, but I'm not sure if there will be a constitutional review even of this matter. But climate litigation has a door open and a different evolution in the three key aspects. Standing, which in the Shell case was said, yes, you can claim, which was a very important win for climate litigators. Then the causality link, which in a way was somehow skipped as a deep legal question through this unwritten standard of care, or maybe it was replaced, the causality link based on this standard. But then it comes the matter of the end, which is damages. How damages will be calculated in cases where there is climate-related liability, especially if causality is not determined, and therefore the damage cannot be specifically pointed out in certain consequences. Calculation of damages will become, I don't know if the word speculative will be the best, but probably it will be the case. And I can tell you from our experience as an organization, when we have had claims, which are in the public domain, by the way, in the United States against matters related to market matters, the damages that OPEC is requested to pay verge in the trillions of dollars, because they said that is the impact of a certain thing. So when causality is not clear, I think there is an enormous risk to go into speculative damages. I don't think I can use a different word. But anyway, that's why experts exist, and I'm happy we're with several of them around the table today. Just to go back to the beginning, let's not forget in which context we're talking. We're talking about climate obligations. So the guiding star for OPEC and its member countries is the Paris Agreement. OPEC member countries have endorsed, signed and ratified the Paris Agreement, all of them except one that has not ratified, it has signed, Libya. But all of them have signed, and let's remember what it says. It says there has to be a reduction of global greenhouse gas emissions to limit the global temperature increase in this century to 2 degrees, trying to achieve a 1.5. And I am forced to remind everyone this because somehow the narrative has been built around 2050 and 1.5. Paris Agreement is quite clear in a different time frame and a different obligation. And I'm not saying this as a justification to keep burning everything that we can to produce energy, but in the context that we have different obligations to observe, and not only environmental obligations. This graphic, just for your consideration and to bring a bit of reality to the discussion as well. I heard the previous presenter saying that we need to be scientific, and I think that is probably the most important statement when we're talking about climate matters. Let's not be ideological. This is not a religious belief. These are facts. And the fact is that this is a projection that our organization has that is very similar to multiple other organizations. And the consumption of oil and gas and nuclear and hydro and biomass, and of course, renewables will increase in the next for 20, 25, 30 years, because there is an unmet energy demand around the world. The fact that developed countries have met their energy demands doesn't mean that all the world has met its energy demands. And in the graphic you see in this slide, you see in the right, the increase or decrease of oil consumption in the world. Indeed, it's true that OECD countries will be reducing their oil consumption, but other countries around the planet still need to catch up. And then is when the importance of the analysis of the environmental obligation comes in a context of the global obligations that we have, or the states have, and corporate citizens have to observe and hopefully to achieve. environmental obligations, development obligations, and energy obligations. These are conflicting rights at some point, and probably we won't be able to satisfy all the rights and in their fullest at the same time and with the urgency that we will wish. But we will try. We should try or strive to achieve all of them as much as we can. Other actors are becoming also a bit more realistic regarding this matter. You heard President Biden saying that we were going to need oil at least another decade. And also other oil companies that were very keen on going into renewable energy and divesting from oil and gas, etc., are trying to be a bit more realistic with their discourse. So what BP said recently, what the other companies have said, and this is because of this graphic this here. We have different scenarios, and you will tell me which looks more realistic than the other. And the left, we have what OPEC projects. The blue line is the reference case. The advanced technologies case implies a reduction of oil demand, as you can see, in the long run, but from 100 million barrels of oil per day to 90 million barrels of oil per day. Whereas in the right side, you have what BP is saying. BP is saying that from 100 million barrels per day, we will move to 20 or 40 in 25, 30 years. If you see how the pattern of consumption goes historically and where the technology is now, I think that it doesn't seem too possible. But anyway, this is, again, as I said, a bit of context. What about environmental, social, and governance standards? As we know, these are a set of standards that try to measure the impact of business from the sustainability perspective. And as I said, this is wonderful in the sense that allows us to pack in a visible and clear way what corporations are supposed to do. But there are points that need to be absolutely clarified here. And this is something that we, from the, let's put it this way, the state's perspective, believe that ESG can improve or be clarified. There is no universally accepted definition and scope. And here I will be on a personal note mentioning my wife works in the anti-corruption sector. She keeps asking me if ESG includes anti-corruption or not. And I said, it depends. If you look at certain standards, it does. If you look at certain others, it doesn't. And a matter which is probably the most fundamental of them all if we care about efficiency of the use of resources. And then a question, what is the difference between ESG and law compliance? As I said at the beginning, and I will show in the next slide, the obligations that we call E in ESG are all codified in conventions, international conventions of all sorts, ILO conventions, UN conventions, of course, the UNCCC framework. So if corporations will focus on complying the law, maybe even the whole ESG framework wouldn't be needed. I'm happy it exists, as I said, for the purpose of identifying the specific objectives. Then traceability and measurement and accountability. This is fundamental for anything. Carbon removal, for example, which is something that we advocate strongly because it is a viable technology to keep all types of fuel available in the future, is sometimes criticized because there is no clear measurability and accountability. It's true. We need to improve that in that, but also in ESG and in any other solution we propose, especially if we're talking about law compliance. And of course, there are claims of greenwashing. And yeah, that's a different kind of story when corporations are using this just as a PR exercise. And we hope that that happens less and less, to be honest. Oh, now I realize that I could have done this. Just because I see that the time is running out, these are the climate principles that you can get from conventions. These are the environmental principles that you can get from several conventions and legal instruments. So ESG and legal obligations have a lot of overlap. So I wanted to bring to your attention one thing related to the Shell case, environmental obligation, and how everything fits together. Shell should reduce its CO2 emissions by 45% by 2030. That was the decision of the court. But how did Shell decide to do this? Shell decided to start selling assets. But when they sell operations of oil and gas, that doesn't mean that those operations are stopping or are ceasing to produce oil or gas, because this oil or gas, that oil and that gas are needed by some clients around the world. Therefore, Shell might be able to reduce its emissions by 45% by 2030. But the world will have exactly the same amount of emissions. But even worse than that, it will be that these assets will be purchased or may be purchased by private entities, local entities that have zero accountability, financial accountability, external investors, stock exchange monitoring. So my question is, are the investors and climate activists satisfied with the result achieved by the case? Because, you know, if the objective is really reduce emissions, this doesn't seem too effective. It seems that it's just transferring emissions from someone that is sophisticated and accountable to someone that is far less accountable. And this is not the only case where this is happening. Multiple other corporations that are working in spaces where emissions are intensive are being requested to divest by their investors. But it's happening exactly the same. They are becoming cleaning in the books, on the books, but then the planet is not better off. And that is probably something that we will need to assess in our strategies. So anyway, trying to conclude, just saying that the energy trilemma is here, and the complementarity between environmental development and energy goals is absolutely clear. And it is becoming more and more evident with the different events that we are seeing now. Geopolitics are always here. Natural disasters are always here. The supply of energy is not as secure and reliable as we wish if we focus on one source. So we advocate for an all sources energy mix, understanding that emissions are a problem and therefore that fossil fuels, to remain viable in the long run, need to find ways to decarbonize. And that is something in which both the states and private sector are investing billions for years and years. And we hope and we see that the results are improving. And this is probably be another game changer in the next years. And then is when we see this advanced technologies scenario, and with this I will conclude, where this is one of the options that OPEC is seeing for the future, where there is a massive increase of renewable energy sources, which are needed, but thanks to greater deployment of CCUS, or strong investments in hydrogen, increasing adoption of circular carbon economy, energy efficiency measures, other fossil fuels, probably not coal because its carbon intensity is really difficult to manage, but oil and gas may still be around for quite some time, precisely because there is need. And one thing that is certainly a source of conflicts in the future is precisely this disparity of views between different regions of the world. And we hope that these actors, states, international organizations, etc., can sit down at the table and try to find a way to navigate these three parallel challenges that obviously intersect more and more by the day. And with that, in the interest of time, I will conclude my presentation. Thank you very much.